Be seated.
We good, Ricky? Okay. All right. Welcome, everybody, to the final round of the Fall 2024 Dawson and Sod Moot Court Competition. I don't know about you guys, but I'm really excited about this. Are y'all excited or not? Yeah? I've been to about 26 of these things now, and every time I get excited, I get thrilled. I really am inspired to see what transpires here. And you guys, congratulations to you for those of you who were in the LARC 3, the LARC 3 classes who had to compete whether you wanted to or not. Y'all made it through. I think that it's a kind of an arduous process. We all realize that. But I know that I think most of you probably, at least towards the end of it, were having a little bit of fun with it. And whether you realize it or not, you really took a big step in maturing as lawyers. And that's what really the fun thing about this is for me, and I know it is for all the judges who are here today, to see how you progress. Think back when you first started, when you started the rounds. By the end of the week, I suspect you were feeling pretty good about it, most of you anyway. At least until you got to the break announcement, and if you didn't make the break, okay, well, you know, that's the way it goes. But I encourage those of you who really liked it. Kathy Sayre is having a informational meeting, I think, this Friday for those of you who want to sign up for Moot Court. So I encourage you to attend to that and go through the tryouts. I'm going to get through this really quickly, but there's a lot of people that I need to at least mention and say thanks to. Number one is the sponsor of this competition. It's the Dawson and Sod Law Firm. They've sponsored it for as long as I've been around here, and that's 15 years now. So the name Dawson may be familiar with you or to you. There's a statue of Matt Dawson right out here. He was the founding member, one of the founding members of the Dawson and Sod Law Firm, and we thank them very much for their support of this every year. This doesn't just happen. It takes a lot of planning. It takes a lot of work. And the people who are primarily responsible for seeing that gets done are sitting right over here. It's the Moot Court officers, so I want to recognize all of them. Nathan DeSilva, who's served in this role for a year now, he's rolling off. So Nathan, Hannah Sewell, she's going to serve as the bailiff today, and Allie Barnett, they're going to be back in the spring for more of this. So thanks to them. Our barrister officers, we have 2 barrister officers who are predominantly responsible for keeping up with the barristers who judge all the rounds, making sure they get where they're supposed to go. That's Marco Pena and David Sandler. You know, I look at this list, I was thinking about it today, and I was telling the judges before we came out, I had much the same feeling that I had when I was practicing law, and I would get a bill, and it would be time to send out a bill at the end of the month. And I would look at all the people that had participated in the case, and sometimes it was kind of shocking to see that number of people. I had much that same feeling when I looked to see how many people were actually involved in putting this thing on. So let me just run through and make sure I don't forget anybody. Susie Daniel, Lauren Porter, and Jerry Cunningham in the dean's office, they're responsible for making sure we get rooms. And in fact, Susie Daniel is pretty much the room enforcer. Once we have a room, she clamps down on it and doesn't let anybody else have it. So thanks to them. All our IT people, Ricky Levecki, Lori Lynn, and Rick Sowell, who have been in here all afternoon setting up this so that we can broadcast it on YouTube. So you guys may have family and friends who are watching. It's thanks to their efforts that gets done. The people in our marketing department, Nick Teixeira, Ed Nelson, Nancy McEachern, all of those people have been involved. You'll probably see Nick popping in and out here to take photographs. He takes outstanding photographs. They're just beautiful. You will have a good record of this that you'll be able to look back on 50 years from now and remember this thanks to the photographs. Thanks to, you won't forget it, I don't think you'll ever forget this. It'll be 50 years. But Nick takes tremendous photographs that are really, really good. Yeah. That's him over there. Thanks a lot, Nick. Allison White. Allison has been helping all along here to make sure everything goes smoothly. Did I forget anybody aside from the judges?
Nobody that I can recall.
Okay, good. Maybe I got everybody. All right, let me go through the judging panel very quickly. I'm not going to spend time introducing everybody to an extent and going on about who they are and where they come from and how they joined us and so forth, but let me just point out on the ends are the winners from the spring competition, Kaya Marie Helmer and Kate Sparks. One of the things that you get when you win this competition is you get to come back and sit on the judging panel, which I suspect might be a little bit easier. At least your nerves may be a little better now. We also, starting from this side and going in, we have Professor Greg White, Professor Richard Albert, Chief Justice Jim Underwood, who is here because he says he knows a little bit about bystander liability. So I think y'all test him on that and make sure that's right. I don't know if that's right or not. Professor Dan Tilley, who's recently joined the faculty. Professor Stephanie Tang. All right? So I'm going to shut up and let us get on with it. The way this is going to work is we'll have the round will take place. The faculty or the judges will then retire and deliberate. They'll come back in and they'll make a decision, announce the decision, and then we'll have an award ceremony after that. And while the judges are deliberating, I expect that there'll be refreshments. So let me just ask one thing. I think they may have some PC exercises going on, so kind of hold it down when you're out in the hallway, okay? Did I forget anything?
Nothing that I know of, although we do, if there's anybody left to thank, it's you and Professor Kincaid for your great work. Thank you, sir.
Oh, well, thank you. Dean Counselor, would you like to make any remarks?
At the end.
Okay. Then,
Follow that. Not immediately.
Mr. Chief Justice, whenever you're ready, you
All
can
right.
begin.
Thank you very much. Would you all like to make an appearance, please? Give us your names and everything.
Laura Monroe, petitioner Max Whiteberry. Grace Neal, petitioner Max Whiteberry.
Kagan Baldry, respondent. Frank Fusemeyer, Bateswood LLP.
And Michael Rowley, respondent, Frank Fusemeyer and Fusemeyer Bateswood LLP.
All right, thank you very much. Petitioner?
Chief Justice, Your Honors, and may it please the Court. Good afternoon. My name is Laura Monroe, and along with my co-counsel, Grace Neal, we represent petitioner Max Whiteberry. There are two issues presented before you today on appeal. I will first address why Max Whiteberry's engagement with Ms. Houston qualifies him as a bystander. Then, my colleague will address why Max Whiteberry's contemporaneous perception of the accident entitles him to recovery. Before I begin my argument, I'd like to reserve 2 minutes for rebuttal with the Court's permission.
Of course.
Thank you. Your Honors, the issues before you today center around a fundamental principle of tort law: to compensate those who have suffered great emotional injury at the hands of a negligent actor. Mr. Whiteberry suffered profound pain and loss when his fiancée was killed just 2 weeks prior to their wedding. To outright bar his claim, as the lower courts have done, would be to dismiss a meritorious claim, one worthy of the court's time and consideration. So, for the following 3 reasons, the Texas Supreme Court should reverse the 16th Court of Appeals and hold as a matter of law that Max Whiteberry qualifies as a bystander.
Counsel, just for clarification, is your client attempting to bring a wrongful death cause of action in this suit?
No, Your Honor.
Would your client have standing to pursue a wrongful death cause of action?
No, Your Honor.
Why is that?
Texas Civil Practice and Remedies Code, section 71.004 is the wrongful death statute in Texas, and that provides a claim to the surviving spouse, parent, or child of the deceased. Neither of those titles does Mr. Whiteberry fall under.
Okay, thank you.
For the following 3 reasons, this court should reverse. First, engaged people fall under the closely related factor of a bystander claim. Second, allowing those in engaged relationships to bring their claim will not burden the court. And finally, the state's interest in marriage is unaffected when an engaged person brings their claim. To my first point, engaged people fall under the closely related factor of a bystander claim. However, as the law stands right now and how the lower Texas courts have ruled, a court in Texas would permit a bystander claim between 2 estranged blood relatives, but would not recognize Mr. Whiteberry's claim. As noted on pages 3 and 4 of the record, Mr. Whiteberry and Ms. Houston knew each other.
Is that where you draw the line? You go from marriage to engagement? Is that the bright line?
We
Counsel?
believe that the bright line should include engaged persons.
Okay, so then I guess my question is, what if it's an engagement only in form? It's for the purpose of immigration. It's for the purposes of military benefits or otherwise. Well, what if it's an engagement of convenience? It's not remotely related to love or other types of close relationship. Is that those things don't matter? We just move the line?
No, Your Honor, those things do matter. However, in deciding today that Max Whiteberry qualifies as a bystander, that's a matter of law, meaning that an engaged person can bring a claim. The things that you mentioned that might attest to the fact that the two were in an engagement for bad reasons would come up in assessing damages, and likely the fact finder would find that the two were not close
But there's
enough.
no inquiry into the relationship. It's just a status. Well, you're engaged. That's good enough. Is that right?
The court would permit a bystander claim outright if the court today allows engaged person to qualify under closely related. However, all those factors come into play when assessing damages. And so that case-by-case analysis would happen in that part of the case.
But Counselor, how do we define engagement?
Yes, Your Honor. So we understand that engagements can look different. However, an engagement is a statement of a future promise that these two plan to get married and enter into that legally recognized relationship.
But counsel, in other areas of Texas law, like under the Texas Family Code, for example, an engagement is not sufficient. Doesn't it seem like those other areas of Texas law should govern the relief you're requesting in this particular case?
Your Honor, it's true that in some cases the Texas legislature hasn't given engaged couples standing. However, the Texas Supreme Court has not commented on this case before you today.
Is there any area of the family code or recognized law where engaged couples have some recognized standing?
Yes, Your Honor. In the Texas Human Resources Code, section 31.015, the state provides funding to premarital counseling, which we suggest shows that the Texas legislature has determined that an engaged relationship is one worthy of statutory protection.
Is that why, or is it just that we are trying to prevent divorce and all the associated issues and ills that come with divorce? Is that not why we're doing the premarital counseling, or is it, from your perspective, just to encourage marriage?
Your Honor, we believe that these codes show that an engagement is the last and final step before marriage. Marriage is the preferential legal status under Texas law, and by providing funding to premarital counseling programs, the state has said that this is an important relationship as they're in the final stages before marriage.
But counsel, there's no consequences to breaking your promise to marry.
Correct.
So, I mean, I don't see how that can be a special relationship if it's an easily breakable promise and a broken promise to marry has no consequences whatsoever. I mean, it seems like not even a papered relationship. It just is declared, which I guess makes it extraordinarily hard to prove that there was or was not an engagement when one of the parties is dead, and makes it exceedingly difficult to disprove the fact of injury. I mean, how would I prove that if you were Mr. Whiteberry that you didn't love that girl, or that you weren't hurt and sad because she was gone? I couldn't defend the case.
Your Honor, the issue before you today is about the emotional injury that Mr. Whiteberry suffered because he lost his fiancée 2 weeks prior to his wedding. It's noted on pages 7 and 8 of the record that he was diagnosed with post-traumatic stress disorder and depression because of this accident. Further, his close friends testified that his personality had completely changed because of this. Those things point to the fact that the relationship between the two was deep, lasting, and genuinely intimate.
Yeah, but you're not asking for a rule just for Max Whiteberry. You're asking for a change in the law that permits all engaged couples to recover for bystander injuries. And they might not all have as definitive medical diagnosis as Mr. Whiteberry might have, right?
Correct, Your Honor. And we understand that the court could be concerned about foreseeability and that it's important that a tortfeasor knows to whom he is liable.
Well, that's not, foreseeability is not my question. My question is like, aren't we leery of bystander injuries because they are both hard to disprove and exceedingly unkind to disprove? To have a witness on the stand and say, you didn't really love her, did you? You're not really hurt by that. You're just making all this up. I mean, that's a horrible case to have to try. And you could never prove what their feelings were that they claim entitles them to compensation.
Your Honor, I would disagree and say that these things you can prove. Again, we saw that his close friends testified to the relationship, especially in today's day and age, how people represent their relationships online or to other people. Those things can speak to the degree of closeness that the two had. And further, these claims...
I hate to hear you sponsor what people say online as being proof of what's going on in their heart and mind. Do you think that's really true?
Not always, Your Honor, but I think that people nowadays do post those things on social media, and that's obviously not a dispositive factor to consider.
Counsel, I follow what you're saying, that this could be proven that you were or were not engaged, but to me that sounds like an issue that would go to the jury rather than, I mean, you said your point too is that this would not burden the court. And instead of having a bright line rule which will filter claims at the gate, it sounds like you're proposing that every claim would go to the jury for the jury to then determine who's engaged, who's not, and then even further how close they were for damages. So going to issue 2, how does this not burden the court?
Yes, Your Honor. Just because a person has legal standing as an engaged person does not mean that that automatically goes to damages. Further, these claims are subject to scrutiny. And it's important to note that the inquiry made into a relationship is the same regardless of that relationship. If a bystander claim was brought by a spouse or a parent, the inquiry into that relationship and the evidence considered is the same evidence and inquiry made that would be made in an engagement. So just because 2 people are unmarried, that doesn't make that inquiry into the relationship any more intrusive or burdensome on the court, as it's the same thing they do for other relationships.
Well, but doesn't it? Because if you're married, there's a bright line rule. You can show a marriage license and show you're married. If you're engaged, is it when you have a ring? Is it when you say yes? Is it when you've told your family and friends? Is it when you've posted on social media? There's a lot more inquiry into engagement than there is with a bright line rule of marriage. So it sounds like it's burdening the courts.
I would disagree, Your Honor, because the law would allow a blood relative to bring a claim. However, there's a high possibility that 2 blood-related people are estranged or distant, and the court does not consider it burdensome in those cases when determining if a blood relative is somehow estranged.
But we're talking about who gets to go to the jury. And there's a door at the front saying, okay, if you're married or if you're a blood relative, then you get to go in. And you're asking us to widen that door and now say if you're at all claiming any sort of engagement or near marriage relationship, then you get to go in.
Correct, Your Honor.
You know, you don't seem like you're shying away from a bright line. You just want us to move the line. And I'm not sure what's changed since this court adopted the Dillon standards to make us change the law. And no matter where we draw the line, there's always going to be the next case, somebody just outside that line, the best friends for life, a couple where the man has given the woman a promise ring, or they've been going steady for 6 years, or they're living together but not engaged. And why should we move the line for engaged couples? And if we're going to do that, what's to stop us from moving the line in the next case?
Yes, Your Honor. However, an engaged relationship is distinct and different from that of a close friend or a distant relative or even a mere bystander. The commitment that the 2 have made towards one another, the duration of their relationship, the dependability on one another, all of those things are different in an engagement than best friends for life.
But counsel, all those things are different in an engagement, just as you said. So, I mean, are you going to put a time limit on it? Does it matter whether the person had just asked someone to marry them or they've been engaged for 8-10 years and people are wondering, is this ever going to pull the trigger? Is it ever going to happen? What about those factors?
Your Honor, again, those would be something that the fact finder would consider in determining damages. The request today is merely that this court would elevate an engaged person to a neutral status. As the law stands right now, Mr. Whiteberry is barred from even coming into the courthouse with his claim. We just ask that he be allowed to present his case and that all those factors that might negate or lessen his compensation be determined by the fact finder in assessing damages.
Counsel, what's wrong with just having a bright line rule at common law marriage? It sounds like all of those elements that are required under the Texas Family Code for a common law marriage fit under what elements you're saying that we should consider for an engagement. Holding out on social media, cohabitation, agreement to be married. I know this is different in terms of present agreement versus engagement, but it seems like that would be a bright line test we can adopt that's moving the pendulum a little bit. What's wrong with that?
Your Honor, the issue before you today does not revolve around a common law marriage. And in ruling for an engaged person to recover under a bystander recovery, the ability of a person in a common law marriage would not be affected.
Would your client meet the test in Texas for a common law marriage?
I am unsure, Your Honor. I apologize. I see I'm almost out of time, if I may briefly conclude.
Go ahead.
Thank you. And for the foregoing reasons, the Texas Supreme Court should reverse the 16th Court of Appeals. Thank you.
Go ahead.
Chief Justice, Your Honors, and may it please the Court. My name is Grace Neal, and I will be continuing arguments on behalf of the petitioner regarding the second issue, Mr. Whiteberry's contemporaneous perception of the accident, entitling him to recovery as a bystander. Your Honors, this case is an opportunity to apply a foreseeability standard to bystander recovery, which furthers the goals of tort law. It is essential that individuals have a remedy for the wrongs that they involuntarily experience. Bystander recovery recognizes the shock experienced from a contemporaneous perception of a loved one's harm is foreseeable and must be redressable. This court has previously decided a case requiring that the bystander is present at the time of the accident. While this is controlling, this is the law because this court made it that way. This case is an opportunity to reconsider that decision and the bystander inquiry in a manner that recognizes the equal and significant harm inflicted upon a class of bystanders who do not actually witness the accident occur. This court should reverse the lower court's decision granting summary judgment for the respondent for three main reasons. First, actual observance of the accident is not required if there is otherwise an experiential perception of it. Second, the contemporaneous perception factor should be applied as in the Texas Supreme Court case, Freeman v. City of Pasadena. And finally, Max Whiteberry had an experiential perception of the accident sufficient to constitute a contemporaneous perception of it. To my first point, actual observance of the accident is not required if there is otherwise an experiential perception of it. Tort law, one of the primary goals of tort law is to compensate victims by awarding damages to the victim against the negligent tortfeasor. Tort law has recognized a series of expanding approaches for recovery for emotional distress. First, under the impact rule, it was sufficient if a plaintiff also had a physical injury occur with the emotional distress. Then, under the zone of danger test, it was sufficient for the plaintiff to be merely close enough to fear for his or her own safety. Then, under the Dillon rule of foreseeability, the court considers various factors to determine whether the injury to the plaintiff was foreseeable to the tortfeasor.
Wasn't the court doing more than that? Wasn't the court trying to draw a line to capture the most significant emotional distress injuries? I mean, because it's foreseeable anytime you cause an accident that you're going to make a lot of people upset, right?
Yes, Your Honor.
So wasn't the California Supreme Court trying to carve out the exceptional scenarios where people would be most likely to suffer the greatest emotional distress?
Yes, Your Honor. The court in Dillon v. Legg in the California Supreme Court designed factors to guide the resolution of future bystander claims. The court in Dillon recognized that administrative convenience both destroys the public's confidence in the courts to determine each case individually on its merits and compromises the courts or destroys the public's confidence in courts. The court explains that no immutable rule can determine the extent of one's obligation or duty for all circumstances of the future. The fixing of obligation is intimately tied into the facts and dependent upon each case. Thus, duty or obligation must be adjudicated on a case-by-case basis. As the court in Dillon states, these factors were designed to aid in the resolution of future bystander cases.
But the court ultimately said that these were prerequisites, not just factors, right?
Yes, Your Honor.
And that's what Texas has followed, right?
Yes, Your Honor. In Thing v. Lechusa, the California Supreme Court determined that these factors are to be treated as requirements, and we are not arguing today that they shouldn't be. We are arguing that they should be applied as in the Texas Supreme Court case Freeman v. City of Pasadena.
So you want to change two of the three factors. What's the legal test you want us to adopt?
Yes,
Because
Your
we
Honor.
have to give guidance to the lower courts what the plaintiff has to have, right?
Yes, Your Honor. The inquiry for this factor, treated as one, should first ask whether the plaintiff actually observed the accident, and then the inquiry must consider whether the plaintiff otherwise had an experiential perception of the accident sufficient to constitute a contemporaneous perception
Where
of
did
it.
that phrase come from, and what does it mean?
That phrase came from the court in Dillon v. Legg, and it refers to the perception of the accident from one of the five senses. This court in Freeman v. City of Pasadena adopted the factors in Dillon, and the Dillon factors provided two guidelines to determine whether a duty existed and therefore the injury was foreseeable. The first guideline inquired whether the plaintiff was located near the scene of the accident, which was contrasted with one who was a distance away from it. The second asks whether the plaintiff experienced a sudden shock, a direct emotional impact upon the plaintiff from the shock of a sensory and contemporaneous observation of the accident, which is contrasted with one who learns of the accident from others after it occurs.
Isn't that exactly what happened in this case, though? Your client learned of the accident from somebody else after it occurred?
No, Your Honor. The petitioner received a phone call from his fiance's father regarding the urgency of the situation. On the record at page 6, that phone call said, "Max, it's Semolina just down the street, come right away." And while this did indicate some urgency, it did not incite the petitioner's suspicion that an accident had occurred.
So how do we craft a rule for when, and you're calling it an accident, doesn't seem like it was much of an accident, but how do we craft it so when it begins and when it ends? Because from your perspective, he did contemporaneously experience the event, right? So when did that event begin and when did it end? Because she had already been struck by the time he showed up, right? In fact, EMS was already present. So where do you set the lines for when an event begins and when it ends?
Yes, Your Honor. Other state courts of last resort have recognized bystander recovery when the plaintiff arrives on the scene soon or immediately after the accident occurs, but before substantial change in the victim's condition or location. These courts recognize that the requirement for bystander recovery is both temporal and circumstantial, and these courts conclude that the interest in personal emotional stability is worthy of legal protection. And so this rule acknowledges that the shock is just as great upon coming across an accident unwittingly after it occurs, but before substantial change, as one who actually witnesses the accident occur.
So if a loved one hears about an accident and goes to the hospital and sees their family member suffering in the hospital before they expire, would that meet your experiential perception test?
No, Your Honor. In that circumstance, they would not have unwittingly come across the accident scene and they had learned of the accident before it occurred, and there is substantial change in the victim's
So you're saying
condition and location.
that them being upset would not be foreseeable if they just get to the hospital? That's not foreseeable, that they're gonna be upset?
No, Your Honor, that's absolutely foreseeable that they would be
But you want us to
upset.
draw a line between your case and that case, right?
Yes, Your Honor, we think that the line should be drawn when there is substantial change in the victim's condition or location, as well as whether or not the plaintiff learned of the accident prior to coming across the scene.
What about a hit
When you draw this
and run?
new line, do you exclude people who are not family members, but who are experiencing the trauma and, accident and the injuries? Because if I had been on the corner and seen that car strike that girl and pin her against the wall, I would have post-traumatic stress syndrome from that. But your test doesn't seem to allow me to be compensated for that, even though it's foreseeable that I would suffer.
No, Your Honor. While that might be foreseeable that you would experience emotional distress from witnessing the accident, as you heard my co-counsel discuss, there are multiple factors as to the bystander recovery requirements or factors, and so this factor would be balanced with the fact that there's also a requirement for closely related.
I mean, the reason we have this rule about bystander recovery is we're suspicious of bystander claimants. They're making up their injury. And so we make these rules and limit it to the people that we all agree would suffer emotional distress if they saw this. And that includes wives and husbands and spouses and blood family members. We all know they would suffer. Everybody outside of that circle, they look a lot more like a random visitor to the scene who undoubtedly is shocked, but is not worthy of compensation. So why would we change that rule to say your proximity or temporal relationship to it is also subject to ad hoc factual determination?
Yes, Your Honor. I respectfully have to disagree. I believe that a fiance would be included in that group of people that would be foreseeable to experience
I
emotional
get
distress.
that argument's being made, but right now it's not. Fiancés are not included yet. Right?
Right. The Texas Supreme Court has not commented on
So,
that yet.
so under your test, the primary victim has to still be alive when the family member shows up. They have to still be alive and at the scene of the accident.
Yes,
And
Your
if
Honor.
so, we have the experiential thingy.
Yes, Your Honor.
Okay, so a couple lives out in the country, and every morning the husband goes out and rides a bike. And on this particular morning, the husband goes out and rides and is struck by a truck. The truck continues to drive away. It's a hit and run. His wife does not come out until 2 hours later, finds him on the side of the road, unconscious. He's at the scene of the accident. Is she a bystander to the accident, the event?
Yes, Your Honor. Because the victim was still at the scene of the accident and there is not substantial change in the victim.
So she doesn't see the individual, she doesn't see her husband get hit by the truck. She only sees him on the ground, unconscious, injured. That is sufficient from your test.
Yes, Your Honor. Courts have recognized that the shock is just as great upon unwittingly coming across an accident and observing the immediate aftermath of an accident and the traumatic events that follow when following closely on the heels of an accident. In that circumstance, although there is some time delay between when the plaintiff would have arrived at the scene of the accident, it seems that the unwitting nature of it would outbalance the fact that there was a period of 2 hours between when the plaintiff left her home and came across the accident
But
scene.
if that's the test, unrelated people suffer the same shock.
Yes, Your Honor, but in considering this claim today, bystander recovery is designed to balance a number of factors to ensure the foreseeability of that emotional distress. And courts have
But it is foreseeable that if you bounce over the curb and hit somebody, it's foreseeable that everybody that saw that is going to suffer a shock, and it's going to be unusual, extraordinary, and perhaps lasting. I don't understand how you can make the argument that this guy who saw it later is entitled to recover and not include people who actually saw the whole thing.
Yes, Your Honor. Courts have recognized that although foreseeability is designed to limit the number of people who are able to bring claims, that there are some arbitrary lines that need to be drawn. And in bystander recovery, courts have repeatedly recognized that these are the requirements as established by the court in Dillon v. Legg.
Right, and the arbitrary line just happens to be, when we're talking to your counsel, you gotta be married. When we're talking to you, you gotta see it. And those lines may not seem fair, but we gotta draw the line somewhere.
Yes, Your Honor. I see that I'm almost out of time. Would I be able to respond to that question and briefly
Sure,
conclude?
go ahead.
Yes, Your Honor. While there does have to be a line drawn, the line that we're asking to be drawn today is that when a plaintiff unwittingly comes across a scene and experiences the shock of coming upon the traumatic injuries of a loved one, that is foreseeable and should be redressable under bystander recovery as applied in the Texas Supreme Court case, Freeman v. City of Pasadena. And for these reasons, Max Whiteberry had a contemporaneous perception sufficient for bystander recovery. This court should reverse the lower court's decision. Thank you.
Thank you. Respondent?
Mr. Chief Justice, Your Honors, and may it please the court. My name is Kagan Baldry, and along with my co-counsel, Michael Rowley, we represent the respondents, Mr. Fusemeyer and Fusemeyer Bateswood, LLP. Today, I will be addressing the first issue as to whether Mr. Whiteberry should recover according to the closely related factor. And my co-counsel will address the second issue, that of location and contemporaneous perception. This is a case about making the difficult but necessary decision to properly define Texans' duty of care and provide a rule that courts can replicate in the future. This court should reverse the 16th Court of Appeals decision to grant summary judgment, or should affirm, the decision of the 16th Court of Appeals for the following three reasons. Number one, Texas courts have consistently required the presence of a legally defined relationship. Number two, to rule otherwise would be to create an unnecessary burden for the courts going forward. And number three, to maintain the line already established would be consistent with the origins of this cause of action and with tort law broadly.
So counsel, I'll ask you the same question I posed to your opponent. Would you be in agreement to pose a bright line test for a common law marriage?
There's no reason to make that decision today, Your Honor. For the bright line of marriage is sufficient, it's replicable, and it is something that the courts can stand firm on going forward. And it also clearly meets the close relationship test that was adopted in Freeman before this court. On page 23 and 24 of the record, the dissent attempts to rely on the concurring opinion from this court in the Freeman case. That concurring justice at the time recognized that in the adoption of the test that non-blood related relatives should be allowed to recover under the test. That was in the context of a 13-year-long stepfather to stepson relationship, and the presence of a legal relationship was there between the stepfather and the mother of the children. Further, that same concurring justice recognized that a line had to be drawn. The dissent further relies on Texas court precedent, such as recently in the Eastern District of Texas, where a father-in-law was allowed to recover. But again, a legal relationship was present there as well.
So for over 175 years, members of the LGBTQI community were prohibited from marrying. So when we think about the traditions and histories of the state of Texas, those who could not marry and yet were very much in cohabitation and loving relationships, right? So if we look back at those cases, we would be excluding a significant number of individuals who we would have proclaimed had no right regardless of foreseeability. So my question to you is, how is it that this, at least as applied, doesn't have a disparate impact on the gay community, given that historically they have been foreclosed from marriage, and therefore, to a large degree, do not seek out that particular type of union?
Yes, Your Honor, that issue is not before the court, and the legal landscape around that issue has changed in the state of Texas and across the country.
But the rule that this court adopts very much has an impact on those types of individual claimants who would be suffering from harm. So we're just to ignore that and go, well, that's not before us, because obviously the impact is.
No, Your Honor, the close relationship factor can still be particularly applied, and it does not speak to future applications of
So you would
different
say that
fact
we
scenarios.
can use the nature of the relationship without having to say there has to be an actual marriage or much less an engagement, is that right? Is that what you're saying?
Well, Your Honor, the close relationship factor has consistently, in the state of Texas, been applied to legally defined relationships. The legal landscape around that issue that you're discussing has changed. The courts have recognized mother and son relationships, obviously married relationships, even again, as I said, father-in-law to daughter-in-law relationships recently. But none of those do anything to expand the rule, and it would be unnecessary to address an issue that we recognize the legal landscape has changed around, but is not before the court today.
Maybe
as
let's
it
get at it
pertains to
this way then. Why today is the existence of these formally recognized legal relationships important to deciding who gets to recover for bystander injury? What are we gaining by drawing the line there?
Yes, Your Honor. We are gaining administrative clarity and removing the burden from future courts and making decisions as a matter of law as it pertains to this subject.
That's what courts are for.
Yes, sir.
To administer justice to people who've been injured. To look at our court and say, we don't want to bother you with this. Seems to kind of dishonor the purpose that we exist in the first place. So let's set aside inconvenience and talk about social, economic, or other kind of benefit we're getting by drawing the line at legally recognized relationships.
Yes, Your Honor. As the Chief Justice noted earlier, this is a duty of care matter, and it has to do with properly limiting it, properly defining it. And so when we're talking about duty of care as a matter of law, there's obviously a test that goes to defining close relationship. And the courts of appeals have done that. This court has done that when considering the original case in Freeman, the city of Pasadena, when it was a relationship between a stepfather and a stepson. Courts of appeals have considered relationships with cousins. They've considered relationships with coworkers. And they've been able to properly draw that line for the
I get that we're
policy
drawing the
of-
line. I'm wondering what the benefit is
Yes, sir.
that we are obtaining by doing that, because what the petitioner is arguing for is that juries understand human relationships, perhaps better than judges do. And they can recognize, that this person had a relationship with the injured person such that we can legitimately understand that they are suffering because of what they saw and witnessed. Other people don't have that kind of relationship, and juries can recognize that. And so they're asking us to recognize that we can trust juries to understand what people's relationships are in reality. You're telling me, don't trust juries, just use the definitions. You'll be happier for it.
Yes, Your Honor, this is not a matter before the jury, and as you pointed out earlier, the definitions that require meeting that initial threshold, reaching over the hurdle to actually enter the courts, have to be addressed with particularity, and they can be before the court, before we unduly burden the courts with other relationships. Again, if we, as to draw on a hypothetical from earlier, a long-term friendship would be indistinguishable from an engaged relationship if we recognized it because of the types of factors you would have to consider to recognize its legitimacy.
And what benefit are we getting by cutting out best friends? Because it seems like to me that juries every week are asked, do you think that this plaintiff suffered mental anguish? Do you think they suffered loss of consortium? Do they think they suffered the a loss of the enjoyment of life? All of which are these intangible, non-economic damages. And juries are asked to understand whether those damages are real. It's the same question here. Do you think that this person, Max, suffered because his fiancée got hit? with a car?
Yes, Your Honor. We recognize that he suffered, and unfortunately, and for the proper reasons,
So what are
mental
we
anguish is
gaining
not the
by
standard.
cutting him out of recovery? What do we get from that?
There's always going to be people on the outside of the line, and Texas courts have to be able to properly adjudicate cases
Yeah,
that
my
we
concern
agree.
is the number of people that we are continuing to throw outside the line. See, if we continue down the road that you're going, we fall further and further away from societal norms. So right now, the number of individuals who are cohabitating instead of choosing marriage is increasing. The number of individuals that are choosing to engage in marriage is decreasing. The age at which people even decide to marry is getting older and older. So your bright line rule, as you said, it would exclude individuals, right? And it seems to me would exclude increasingly more individuals despite cohabitation, financial codependence, intimacy, and other significant factors. Isn't that what your rule does?
Yes, Your Honor, it does. It does exclude certain parties, and there will always be people on the outside looking in. Ultimately, this court can't make decisions because of the number of possibilities that exist. It has to properly define duty of care as a matter of law for courts to be able to replicate that. Even in the California Supreme Court that adopted this case, having the most experience with the factors, they recognized the fact that after time, with this cause of action on the books, that foreseeability could not be a standalone justification, and that cohabitation without formal marriage could not constitute the level for recovery. Being
But
that
in
the
Texas,
factor,
in Texas, a common law marriage is established by cohabitation and holding out. One does not have to get a license from a justice of the peace. So how is it, to my colleague's point, how is it that we are actually asking courts to do that much more? They're having to go into the fact-intensive inquiry as to a common law marriage than we would as to the nature of cohabitating individuals who are financially codependent and or engaged or otherwise.
yes, Your Honor, a cohabitation of a long-term relationship or common law marriage is not before the court today. And as a number of you have pointed out, bystander recovery is a modern tort concept, a necessary one, but it is on the outer edges of causes of action, newer causes of action that are recognized by courts broadly and by Texas specifically. It is right that courts are wary of folks bringing claims when real injury cannot be tangibly agreed upon. To have a repeatable standard and to not overthrow it for this purpose when it would, based on the factors and the facts that are present in this case, would undistinguish close related from any other type of relationship that is not legally defined.
But don't courts use foreseeability all the time? I mean, you mentioned that this bright line rule is consistent with the origins of tort law, but the origins of tort law is foreseeability. The Dillon case bases its assessment on foreseeability. So isn't your proposed rule inconsistent with the origins of tort law?
I disagree, Your Honor, with your characterization of how the California courts have applied that rule. They said, by quote, the evaluation of these factors will indicate the degree of the defendant's foreseeability. The factors are how we have to define foreseeability in this cause of action, because that's how it was created at the beginning. And it was because of serving the purpose of ensuring that those parties or claimants that would come forward without a distinguishable and verifiable injury cannot overburden the courts with more cases than the courts can handle or manage.
So clearly here, the decedent's father would be able to cover under Dillon, right?
Yes, Your Honor. And
he was there, he witnessed the entire event. Does it bother you at all that we allow the father who's about to lose his daughter to recover, but deny the fiance who's about to gain his wife to recover? Is his harm no less foreseeable or significant?
Your Honor, your
or
father,
life-altering?
The father settled, and yes, Mr. Whiteberry has suffered a grave loss, but ultimately the factors, the elements that are being applied today don't filter it through whether or not mental anguish was suffered. As this court pointed out,
counsel's proposal is just to enlarge the definition of who has standing a little bit further, and I don't think the courts are going to be overrun if we do that, and it seems fair and meets the definition of foreseeability. Right, what's the big harm here?
well, as this court has recognized today, Your Honor, bystanders are unfortunately on the road every day in car accidents. We're all very aware of the Texas Department of Transportation Stop the Street campaign. As soon as it's based on mental anguish or foreseeability generally and not tied to the factors as they were initially adopted, then there's always going to be another question. As soon as you expand the line once, then the case that is now closest to the line will be the one that comes before the court. And a number of bystander claimants will then be emboldened to bring their claims on the basis of simply winning something.
Opposing counsel already walked through the history of emotional distress claims. The lines have continued to change over time. Dillon's been on the books for decades now. Maybe it's time just to slightly alter that line.
A history, Your Honor, of a line being moved does not necessitate that it be moved today or that it requires that the principle should change. Just because a concept in the law has age or years established doesn't mean that it's not a good principle to follow. Ultimately, close related is in the definition, and it's even presupposes a legal
I hear you
define-
saying that we should stick to one bright line test in marriage, but I haven't heard you tell me why, other than, well, that's the way it's always been. I mean, if half of marriages end in divorce anyway, why? What is it about the nature of married individuals other than, well, it's easy to figure out?
Yes, Your Honor. Marriage is the first human institution. It is recognized by the state of Texas for all the reasons that we all recognize marriage for. It does not require us to ask the question as to what it is. With an engaged couple, we are having to define something anew. We're having to set a standard. We couldn't determine whether or not it was for the ring or whether or not it was for some wedding date that was set. It's going to look different in every case scenario, and marriage is not. It's something that the law recognizes clearly.
You're saying marriages don't look differently? So a loveless marriage of 20 years is deserving of more consideration than the situation we have before us today, where we have a long lifetime relationship?
Chief Justice, I believe I'll round a time with this question. May I respond?
Go ahead and finish and wrap up briefly.
Yes, Your Honor. As a matter of law, that relationship would be able to meet that first hurdle, but it does not necessitate that over that hurdle would result in civil damages, but yet it still holds the line of not burdening the court with future claimants who are emboldened by an expanded definition. Your Honors, for the three reasons that I've included today, we urge this court to affirm the decision of the 16th Court of Appeals. Thank you.
Go ahead.
Mr. Chief Justice, Your Honors, and may it please the court. My name is Michael Rowley, and I will be continuing arguments on behalf of the respondent with regards to the second issue, the location and contemporaneous perception elements of bystander recovery. Today, we ask this court to affirm the judgment of the 16th Court of Appeals, granting summary judgment to our client, Frank Fuessmeyer, and Fuessmeyer and Bateswood, LLP. This case is about consistency, clarity, and balancing the interests of individuals with the interests of society as a whole. This court should affirm the judgment of the 16th Court of Appeals for three main reasons. First, under current Texas law, a plaintiff must contemporaneously and sensorily perceive the actual accident to recover as a bystander. Second, the contemporaneous perception requirement of bystander recovery provides a meaningful limit on potentially limitless liability and brings necessary clarity to this area of the law. And third, Max Whiteberry cannot satisfy the proximity element as it stands today. Now this brings me to my first point. Under current Texas law, a plaintiff must contemporaneously perceive the accident to recover as a bystander.
Okay, so this is kind of the same problem. We've drawn a line, you have to contemporaneously observe. What are we gaining by putting the line there? What is good for society in drawing the line at contemporaneous observation?
Yes, Your Honor. Contemporaneous observation provides a meaningful limit on liability. It's important to understand that society has an interest in limiting the kind of liability that comes with negligent infliction of emotional distress, such as a bystander recovery, because it's potentially limitless and can impose societal costs that are unacceptable, like extremely high insurance costs that make it so that people that have valid claims can't recover because people can't carry insurance.
Actually, this seems like a very narrow type of claim. We don't see this factual scenario repeating itself over and over again, where people witness this and are not able to recover because of this line, and yet we find them to be deserving of recovery. I mean, I don't get this is limitless. Insurance rates are gonna go out the roof. I don't get where that's coming from, because there aren't that many of these cases out there.
Yes, Your Honor, but in those cases that it does occur, there are a huge number of people that could recover based on the foreseeability that the accident will cause emotional distress. As you mentioned earlier, there are other people at the accident scene that witness it, or people that can learn about it later, like relatives and friends. And this group can just continually grow and grow and grow for one accident that occurs.
Okay,
So,
and every week we try cases that have these intangible injuries, and the question for the jury is both, is the injury real? And then secondly, what amount of money will compensate for it? They try that issue every week in every courthouse in Texas. This is no different. Is the injury real, and what amount would compensate for it, is the two questions you're asking for Max Whiteberry. Is his injury real, and what amount of money would satisfy it? I don't see where you get the idea that if we allow Max to try his case, the insurance industry is going to collapse and the court system is going to buckle under the weight of all the claims.
yes, Your Honor, you are correct that if we allow Max to try his case, that's not going to impose the societal costs that potentially limitless liability can impose. And we would not disagree that Max Whiteberry suffered severe emotional distress. However, if we begin to extend the line because of Max Whiteberry, the case in front of us, then there's nothing that stops us from continually extending that line. Especially the contemporaneous perception requirement provides a meaningful limit on liability because it's not based on just the intensity of emotional distress that somebody experiences. Now, when the California Supreme Court created the bystander test in Dillon versus Legg, they did try to carve out what would be most likely in most cases to be the most intense emotional distress that someone experiences. But it would be difficult for this court and other courts to say that someone who unwittingly came upon an accident scene after it happened and someone who wittingly came upon an accident scene suffered a meaningfully different level of emotional distress.
If you say we should limit it to contemporaneous, where, as I asked your opposing counsel, where's the beginning and where's the end? I mean, he did show up, he did see this event. I mean, after all, I mean, even EMTs show up after the fact. So was it already over from your perspective, and why?
Yes, Your Honor, in this scenario, it was already over because the car had already made impact. When we think about when an accident actually occurs, a car accident such as this, I think a reasonable person would consider the accident to be over after the impact has occurred, and then we're witnessing the consequences of that accident.
Okay, so then in my hypothetical before, where the cyclist gets hit by an individual who's driving a truck and just hit and run.
Yes, sir.
You're telling me that the individual, a mother who sees a child run out into the street, right, and the child gets hit, she doesn't see the immediacy of it. She doesn't see the child fly off to the side. That if she didn't see it actually strike the child, that it was not contemporaneous. Is that your standard?
Yes, Your Honor, that is our standard, and that is this court's current standard. If we go back to the most recent case that this court decided in USAA versus Keith, the facts of that case were very similar to the facts in your hypothetical.
What about standard fruit and vegetable? That was this court, and this court said that the plaintiff who came onto the scene after the immediate accident could recover. So haven't we already decided this?
No, Your Honor. The Standard Fruit and Vegetable Co. was an intentional infliction of emotional distress case, and the holding in Standard Fruit and Vegetable Co. had nothing to do with a bystander claim. They did mention in the footnotes of that case that a bystander may be able to recover if they came upon the accident immediately after, but as far as holdings go, the last holding that this court gave was in USAA versus Keith.
All right, but in Landreth versus Reed, we had a situation where an individual comes along and someone is drowned, and then during the resuscitation is whenever the bystander comes upon the scene. And that court said, yeah, that's still contemporaneous. Why should we not take that court's approach?
Yes, Your Honor. In Landreth versus Reed, the court considered the accident to be an ongoing accident. And so the accident had not finished when they witnessed the resuscitative effects, because somebody that's drowning, as in that case, the accident's still ongoing while they try to save the person that's drowning. However, in a car accident scenario, such as the one we have today, you wouldn't say that the resuscitative efforts are part of the actual accident.
Well, in this case, she didn't pass away. She didn't die until on the way in the ambulance. So they were very much trying to keep her alive and working on her when her fiance shows up. In fact, the car had just been pulled away from her. But you're saying, no, he experienced nothing. It wasn't contemporaneous. But with Landreth, after the fact, when the person has already drowned and they're now trying to resuscitate, you're saying that they're the same?
No, Your Honor. I would say that in the case when somebody has already drowned, you wouldn't say that they've already drowned until you know that they've passed away. But in the case today with a car accident, you wouldn't say that she hadn't already been hit by a car when they come
Counselor,
to...
I don't see the difference between these two resuscitation efforts, and I think that we should refocus this into, should we consider resuscitation efforts or not? Because I see merit to the claim that watching resuscitation efforts, especially in something as catastrophic as this, is as traumatic, if not more traumatic, than watching it happen.
Yes, Your Honor, I would agree that seeing the resuscitation efforts, seeing the accident after it's happened when there's no material change, as petitioners argued for, is still going to cause severe emotional distress. But so is learning that your relative was in a serious accident on the phone or later on. People are going to experience intense emotional distress when accidents happen like this, no matter how they learn about it. So if we're going to draw a line that's going to provide a meaningful limit on this potentially limitless liability, we have to be able to draw that line on something different than just the intensity of emotional distress.
Doesn't the state of Texas permit a type of emotional distress claim in wrongful death cases for loss of consortium? Let's just say the answer is yes.
Yes, Your Honor.
Okay. Hypothetically. I mean, in that context, for a loss of consortium claim, we don't have these extra requirements that you've seen the person get hurt and had contemporaneous sensory perception, in part because there's a limited group of people who get to sue under the wrongful death statute. But likewise here, your co-counsel has argued for a very limited group of people who get to sue. Maybe that's the only limitation we need going forward, is to say that close family members suffering emotional distress from learning of the death of a loved one can have standing to sue under Dillon. What would be wrong with that?
That's a good question, Your Honor. We go back to the experience of the California courts who created the bystander analysis. They took an approach similar to what you are suggesting today, where they kind of disregarded the factors and began to view them as suggestions and just kept one limitation, maybe it was the relationship limitation, and just began to view them as suggestions. And they noticed that bystander analysis, bystander recovery continued to expand and expand and expand. And it became very inconsistent between the courts. And so they decided to change the way that they approached bystander recovery and created these precise rules, and actually went with a contemporaneous perception requirement as well in Thing versus Lechusa, which occurred 21 years later. So if we take the experience of the California court who actually created this, we can learn from them that it is important to have additional limits to liability on top of just the relationship factor like in the wrongful death consortium claim. We can also see that lower courts...
Can we just do a little bit of Texas experience, because recently our court decided Gregory versus Chohan about non-economic injuries. And in that case, we said we are dissatisfied with juries simply being asked to pick numbers out of thin air, which is, I guess, what you're worried about in a bystander case. Am I right?
Yes, Your Honor, that's part of the concern.
Okay, so we said no longer will we let juries pick numbers out of thin air. They're going to have to tie a non-economic injury to an actual economic anchor. If your non-economic injury is, I'm sad and depressed and emotionally ruined, then the economic injury has to be tied to, well, what kind of money would it take to solve that problem? Not, would you endure that for $1 million? Well, nobody would. And so we are cabining the amount of recovery without telling people you can no longer recover for that kind of injury. Recognizing the trauma that a guy like Max Whiteberry might suffer, but requiring more detail and specificity about the injury so that it's not limitless recovery, which is what you were worried about. Why don't we just do that?
Yes, Your Honor, I think that goes back to what my co-counsel argued, that if we begin to recognize claims for everyone that has some sort of emotional distress, even if we don't permit them to recover an arbitrary number and we limit the amount that they could recover, we still impose a heavy burden on courts if we just continue to allow
Okay, I'll say
liability
the
to
same
expand.
thing. I'm unpersuaded by arguments that the court will be inconvenienced by lawsuits. So setting that aside, what's wrong with requiring people who actually have injuries to be eligible for recovery, but requiring strict proof of what their damage actually is instead of randomly picking numbers?
Yes, Your Honor, I think that goes back to the duty question, which is the tort foundations that this cause of action is built on. We have to be able to limit the duty of a negligent actor somewhere because our compensation system is based on fault. And so if we consider limiting the amount that somebody can recover but still allowing a large number of people to come into the courtroom and recover for negligent infliction of emotional distress, it becomes inconsistent with the level of fault that a negligent actor might have, which concededly does have a level of fault because Frank Fuessmeyer did act negligently in this case. However, if we continue to allow a high number of people to come in and recover for emotional distress, even if we limit the amount that they can recover, that liability, the duty that's placed on Frank Fuessmeyer becomes inconsistent with his level of fault, which is another reason that we need to have a meaningful limit on liability to be able to prevent limitless liability. This court has an obligation, additionally, to balance the interests of individuals with the interests of society as a whole. I see, Your Honor, I'm running out of time. Can I briefly conclude?
Go ahead and briefly conclude.
Okay. By holding firm on the requirement of contemporaneous perception of an accident, we can strike the balance between individuals who suffer severe emotional distress and the interests of society as a whole. For these reasons, we ask that this court should affirm the judgment of the 16th Court of Appeals. Thank you.
Thank you. What if for petitioner, I believe you reserved 2 minutes.
Chief Justice, Your Honors, and may it please the court. I'd like to touch on two things that the respondents mentioned before you. First, the respondents mentioned that there is a societal interest in limiting bystander recovery. However, bystander recovery instead aims to permit recovery to those with foreseeable injuries. As was discussed, Mr. Whiteberry suffered immense trauma that was easily as foreseeable as if he had viewed the accident. He was brought to the same emotional distress as one who witnesses the accident by viewing the immediate aftermath. You also heard opposing counsel mention that administrative convenience, along with the closely related factor, is important. However, courts make these decisions often. Juries and fact finders are capable of determining whether a claim is fraudulent or meritorious. The same inquiry is made in an engaged relationship. The issue of the law today is illustrated by the fact that if Mr. Whiteberry was walking into his marriage ceremony, the court would preclude his claim. However, if just moments after he was walking out of that marriage ceremony, the court would allow his claim. This is at odds with the purpose of tort law. Again, the purpose is to compensate those who have suffered great emotional harm, as Mr. Whiteberry did. So, for the foregoing reasons and those earlier mentioned, the Texas Supreme Court should reverse the 16th Court of Appeals and hold as a matter of law that Max Whiteberry qualifies as a bystander. Thank you.
Thank you. All right, I guess we'll be in adjournment while we go decide your fate.
Fate.
seated.
Well, I'm just going to have some brief remarks. All of you here, thanks for those of you who participated in the competition. Thanks for your effort. This is kind of the point that when I was in law school, it didn't all come together at the moot court competition, but I could feel it started to, you know? So you start to think like a lawyer, write like a lawyer, and get a chance to speak like a lawyer. So this is a really important point in your education, I think. I want to join Professor Berry in thanking all of those who helped make this possible, especially the moot court officers and the barristers and our faculty. I want to thank our judges who came to do this. It's extra work for you, and I appreciate it. It gives them a really good experience. And I want to thank our competitors. I don't know what the result is, but I felt that was a very, very close round, and all of you should be very proud of what you've done. We do this twice a year. It is an enormous effort. I want to thank Professor Kincaid for her efforts on this competition. And the person who has made this happen for years and years and years now is Professor Mike Berry. So I want to give Professor Berry a round of applause. Our students couldn't have this kind of culminating experience in the first year if it weren't for you, Mike, so deeply appreciate it. I'm not going to linger here much longer. I do want to say attending this was very triggering for me. I competed in the final round of the Dawson-Sod moot court competition when I was in law school, and I lost. And my career has been one unmitigated disaster since. I mean, just moving from failure to failure to failure because of what happened that day. I don't know who the winners are. I don't know. But whoever finishes second, I hope that is some small comfort that there may be some sort of future for you in the legal profession if you do not prevail in ultimate victory today. But thank you all for coming. It means a lot to them to see their classmates here with them. It also, I think, adds a little bit of pressure, which is a good experience for them. So thank you. And now, without further ado, Mr. Chief Justice.
Oh, I didn't want to be the Chief Justice because I don't want to announce the loser, so I'm just going to announce the winner. And you can draw whatever inferences you want from that. No, not a platitude. Seriously, a very close round. We had a spirited debate. They had to lock us in the room. Am I right? So really tough. I mean, we're not deciding who's good and who's not here. We're deciding who was slightly better than the other. So a winner, take that victory with a grain of salt, and loser, you're not really a loser. Having said that, we voted not unanimously, but we voted in favor of the respondent. So well done. Mr. Berry?
Yes, sir. Hello, everyone. I have the honor of presenting the awards to our competitors tonight. So we're going to start off with team awards. We'll be recognizing semifinalists, then our runners-ups, then our tournament's champions. So when I call your name, please come down to receive your plaque from Allie. Beginning with the semifinalists, we'd like to recognize Team 16, Pablo Boada. You can clap after each name, please. And Daniel Turnbull. Next we have Team 12, Youssef Hashmi. And Jake Kala. Now for our runners-up. We have Team 5, Lauren Monroe. And Grace Neal. Now for the champions of this tournament, Team 6, Kagan Baldry. And Michael Rowley. All right, next up we'll be giving out this tournament's Oral Advocacy Awards. These awards are for spots 1 through 10. For spots 4 through 10, I'm going to read off your names in no particular order, so please just stand to be recognized when I read your name. For spots 1 through 3, we will announce your names in order, and if your name is called, please come up here and receive your plaque from Allie. But without further ado, for spots 4 through 10, please stand when I say your name. Jared Miller. Grace Neal. Daniel Turnbull. Aliyah Khan. Tom Malaspina. Callum Wright. Kagan Baldry. And now for speakers 1 through 3, when I announce your name, please come down and receive your plaque. Starting with our third place speaker for this year, please come down, Carolyn Bizarro. Next, our second place speaker is Michael Rowley. And finally, this competition's first place speaker is Lauren Monroe. Now, Professor Berry has one more award to address, but before I turn the mic over to him, I'd like to thank all of you for your support and your attention, and ask the award recipients to please wait by the statue across the hall so we can take pictures of your lovely smiling faces afterwards. So, for now, over to you, Professor.
Yeah, I think we do have one additional recognition we want to make. You know, not infrequently in this competition, we end up with an uneven number of people in the LARC 3 class, and that doesn't work very well when you have a team competition. So at that point, we generally will send out an all-points bulletin for people and ask for volunteers. So you guys watch for that in the future. When you see this, you understand what that's coming from. And, you know, it's a bit of a hassle if you're not in the LARC 3 class to pick up a cold problem in the midst of everything else you're doing, learn the problem, learn the cases, and go in and argue the case. That's a bit of a hassle. So when that happens, we like to recognize that person. And we consider that to be an act of professionalism, recognizing that, you know, we owe obligations to the profession, to our classmates, to counsel, to opposing counsel, to the courts. And we think when people do that, they ought to be recognized for it. We had somebody do that this year, Pablo Boda, who stepped up and paired up with Daniel Turnbull, and they did very well. So sometimes you engage in a little act like that of professionalism, and it turns out to pay off for you. So we do want to recognize him. He's not able to be here tonight. He's sick this afternoon. He's not feeling well. So, but I just wanted to go ahead and recognize him, and we will have an award to hand him when he gets back. So, you have anything else to say, Mr. Chief Justice?
Good night.
We're adjourned.